This is American Government, Monday, November 16th, 2020. Today we're discussing civil liberties as laid out in Chapter 4 of the Wilson text, and Wednesday we'll turn to civil rights as laid out in Chapter 5. My first comment is that the way I've organized this material is many of the brighter and more attentive of you will notice that Chapter 4 and 5 come after Chapter 3 and before Chapter 6, and we've just finished with Chapter 12. Is my problem that I don't know numerical order? No. When I put this course together, I decided that in some ways Chapters 4 and 5 are actually appendices to Chapter 12. In our last discussion, we discussed judicial philosophy, and Wilson in Chapter 12 talks about the evolution of different judicial philosophies over the course of time and the different historical orientations. And one thing you'll notice in these two chapters is that 95% of the origin of the material and doctrines discussed in these chapters was formulated on the Supreme Court. So as you'll see, though, in our last discussion, we talked about the great controversy between judicial originalism, judicial restraintism, as evidenced by Bork, and by the way, generally speaking, as advocated by President Trump and his judicial nominees, Justice Barrett, Justice Gorsuch, Justice Kavanaugh, and to some degree the other pre-Trump judges on the court, such as Roberts and Alito and Thomas. Probably the most forceful advocate of this position was Justice Antonin Scalia, who passed away during the last year of President Obama's presidency. And between that position and the judicial activism, the living constitution expansionist understanding of the task of the judiciary as articulated by Justice Brennan, but also as advocated by Justices Kagan and Sotomayor to some degree, and certainly by Justice Breyer and by Justice Ginsburg, who just recently passed away. So in some ways, I decided to arrange the material as continuing discussions of the judiciary that we began when we turned to first Federal 78 by Hamilton and then Marbury v. Madison and Chapter 12 material in general, since I think you can consider these to be addenda to that chapter and this subject, the subject of the judiciary. In fact, many of the issues described and discussed in these two chapters are embodiments of either one of these two philosophies, as you will see when we move to this material. So as that by way of general introduction and why it comes at the end of the course. More about that in a minute. Well, let's talk about that now. In some ways, you could say that the nature of our rights is what begins and ends this course, and I had a brain freeze moment there. And also because I'm operating on two computers at once, I forgot where the cursor control was on this computer. But anyway, actually before I go on to the next point, one thing I wanted to raise with this first issue was what are civil liberties and civil rights, and then it'll go on to this larger discussion of them. On page 57 of the Wilson text, I'll have to put my additional eyes on. Again, you'll understand when you're 68 years old. Much better. On page 57, this is Wilson's discussion of civil liberties, or definition of civil liberties. And then I'll read from the beginning of Chapter 5, which we'll turn to on Wednesday, his definition of civil rights. But they're really overlapping and really contiguous and really continuous subjects. Civil liberties are the rights, chiefly rights to be free of government interference. accorded to an individual by the Constitution, free exercise of religion, free speech, and so on. Civil rights, to be discussed in the next chapter, usually refer to protecting certain groups from discrimination based on characteristics such as sex, sexual orientation, race, or ethnicity. In practice, however, there is no clear line between civil liberties and civil rights. For example, is the right to an abortion a civil liberty or a civil right? In this chapter, we take a look at free speech, free press, religious freedom, etc. And here's a comparable discussion definition from chapter 5, on page 78. Civil rights cases refer to cases in which some group, defined usually along racial or ethnic lines, is denied access to facilities, opportunities, or services that are available to other groups. The pertinent question regarding civil rights is not whether the government has the authority to treat different people differently, although that is, as you'll see, part of the question. It is whether such differences in treatment are reasonable. So, again, to make my first point in these comments is that the questions articulated in those definitions and the distinction between what Wilson is calling civil rights and civil liberties is in some ways expressed through doctrines and developments in the court and on the Supreme Court especially. So with that in mind, let me give a kind of a general introduction to this topic, which puts it in which raises the question of why we are ending the course with this. Because in a way, it both begins and ends the course, the question of rights. Really, we began this course with the Declaration of Independence, of course, which states the fundamental principles of American government, and of course, as you well know, states that the purpose or the aim of proper government of all government is the securing of rights. And we've ended with the judiciary, whose primary concern in some ways is the definition and application and securing of those rights. Of course, the specific task of each branch of government within its proper sphere and power is to secure those rights articulated in the Declaration of Independence. So it's good, I think, to introduce this topic of the securing of rights, civil rights and civil liberties, with a reminder of why this topic and this issue is inherent in the principles of the Declaration. First of all, because as I've just said, and as we saw at the beginning of the course, the purpose of government, let alone good government, is to secure the rights bequeathed to us by nature that are embedded as self-evident truths in our human natures. Really, to discuss this topic fully, you have to bear in mind three different kinds of rights that our tradition speaks of and that the Constitution addresses. And you can conceive of these as concentric circles. The largest circle of rights are natural rights. Those are inherent in all human beings in all times and places. Some ages and governments have recognized those, some haven't. Generally speaking, the founders of this country and the American Revolution argued that ours was the first nation to adopt self-consciously the principle of modern natural right, as the modern political philosophers such as Hobbes, Locke, Rousseau, Montesquieu, and that we've discussed before had articulated them. So, without any national pride or chauvinism, that self-understanding was correct in the sense that ours was the first nation, followed by France, to be sure, and then all modern nations today understand that the task of government is to secure rights. So, these three classes of rights have to do with how we enjoy our human nature. And of course, natural rights are those that are imbued to us by nature and exist to us in our natural condition prior to the rise of government. They are the purposes of government, the ends of government, because they precede government, according to the Declaration of Independence, because again, these are structural aspects of our human nature. All human beings enjoy these. Now, that doesn't mean all human beings and their rights are secure. Partially, it depends on the nature of the government they live under. What forms the American people are that segment of the human race that has come together and formed a particular American government to secure their natural rights as an American community. The second smallest circle going in from the outside, of course, the first circle of natural rights encompasses all human beings because, again, to repeat, those rights are structured in our natures as human beings. But civil rights are the way I've defined them, are what our natural rights look like once society or government has come into being. Our natural rights are inalienable. Our civil rights, because don't forget the word civil means living in government, from the Latin word for city, or civil, meaning living under political conditions and under government. You don't have civil rights in nature because you don't have society in nature, according to the narrative of the Declaration. But civil rights are the way that your natural rights are secured once the structures of government and society and community exist around you. So those are, for example, free speech and press and assembly, petition and security of property and personhood, the right to due process and fair trials, appropriate punishments such as in the Eighth Amendment. All persons, of course, enjoy these even in American society and government, and this includes men and women. Children have civil rights, and even citizens and non-citizens. So all persons within this category who happen to fall into American jurisdiction have some civil rights. Really, I mean, if you're an alien and you're living legally or illegally in the country, you have certain civil rights guaranteed you by the Constitution and the government. The smallest category of rights are political rights. Those are rights of citizenship, voting, and serving in office. And that's the smallest and inner circle because the right to engage in politics through voting or holding an office is far more limited than the sphere of human beings that have civil rights. After all, aliens are not allowed to vote or to serve office. And young people, children under the age of 18, are not allowed to vote actually in all states. I mean, technically, a state could lower the age of voting, and that's been discussed in our country in some states and localities. But since the 26th Amendment, anyone over the age of 18 can vote, and as you know, the Constitution defines smaller circles of qualified individuals, 25 for the House, 30, and so forth. At one time, in most jurisdictions, women could not vote or hold office, even though the Constitution does use the word person, and therefore it was always open to this question. So, and of course, in some jurisdictions and at some times, access to the franchise and to serving in office was restricted by race. But nevertheless, the sphere of political rights is the smallest, the sphere of civil rights is larger, and the sphere of natural rights is all-encompassing. How does our government exist to secure these rights? The original Constitution secures natural rights by creating a structure of limited but effective power, limited government, separation of powers, checks and balances, and places. We'll come back to that in a minute. So in some ways, you have to remember that the core way to secure our natural rights, according to the Declaration, is to form a government, a good government. A government has the power to govern, but not the power to tyrannize, which is why our theory of government is called limited government. And in various ways, the framers experimented with certain limits of government, finally perfecting those limits, or at least bringing them to their fullest extent in the founding of the Constitution. Then, so the overall Constitution and its structural elements are the primary ways that our natural rights are secured. But then in certain parts of the original Constitution, certain civil rights are given prominence and visibility. Article 1, Section 9, no bill of attainder, no ex post facto law, the writ of habeas corpus in Article 1, Section 9, and other limitations like no titles of nobility and ex post facto or bill of attainder laws. Protection, as I said, of the right of habeas corpus. In Article 3, Sections 2 and 3, guarantees of trial by jury. And Article 3, the definition of treason and limitations on the definition of treason. Those are all ways of securing our civil rights. And of course, aside from those portions in the original Constitution, the major visible part of the Constitution that addresses our civil rights are the Bill of Rights and the subsequent amendments that deal with or expand or solidify individual rights and immunities. So, um, and you'll see that in some ways, aside from the extent and character of these rights that we enjoy in civil society, balanced by the necessities of good government and society, as you'll see, I'm about to address that point. As you'll see, the major debate in our country is when it comes to the Bill of Rights, what has been the scope and the applicability of the civil rights given visibility and prominence in the Bill of Rights and other amendments to the states. More about that in a minute. But here is the critical thing to remember with respect to the enjoyment of our rights. There isn't even this is a complex point to express. The aim with our liberty and our government and the extent of government and governmental power is to find a middle ground where the essence of our natural freedoms and rights are preserved so far as possible in civil society consistent with good government. In our state of nature without government, those rights are absolute, but that's the very condition of insecurity, if you remember when we discussed the Declaration, that leads to the necessity of government. Once you're living with other people under government, then you can't have absolute rights. So the task of good government and civil society is to find the reasonable limits on our freedoms. And you'll see that that's both the task of government in general, and in some ways that is the unique task of the judiciary. But bear that in mind that even and this you could say that this is one of the lessons that we've living under constitutional government and the Bill of Rights is none of the rights in the Bill of Rights is absolute, although some justices have held such. But that would ultimately destroy government, which would render rights unsecure. You can sense the complexity of the issue the moment you begin to think it through. The task of good government is to secure as much of our personal freedom and liberty as is consistent with living in society with other human beings and under conditions of good government. And we'll see that borne out by these doctrinal debates and the substantive issues with respect to some of the rights of the Bill of Rights that we'll talk about. So, about the material in Chapter 4. The biggest change in our constitutional system since the time of the founding has been the application of the Bill of Rights to the states through the 14th Amendment by means of, and I chose each of the words in this designation on the notes quite deliberately, through the Supreme Court's incorporation doctrine. Now, here we need a bit of history. You know that the Constitution was created and ordained. You know that, as we saw in the ratification struggles, many of the state constitutions prior to the Constitution were prefaced by or followed by a listing of bills of rights. The notion of a Bill of Rights goes back to actually English history in 1688, the Glorious Revolution, when James II was chased out of the throne and William and Mary of Orange were invited to come over and be the new king and queen. And at the same time, the Parliament passed a listing of fundamental English rights called the Bill of Rights. And that's where the whole tradition of listing rights in visible places in fundamental treatises of government came from. Well, when we declared independence from Britain, most of the states, when their new constitutions adopted prefaces as Bill of Rights, and or as a concluding epilogue. Well, as you know, the original Constitution didn't have a Bill of Rights, and because the framers didn't think that was necessary, because the Constitution was so well designed. But as you know, at least three members of the Constitutional Convention refused to sign the Constitution for other reasons, among which were no Bill of Rights. And when the Constitution went through the different ratification conventions in the states in 1787 and 1788, it became more and more common for the state ratifying conventions to ratify the Constitution with the promise that there would follow subsequent listings of rights because of the general fear on the part of the states that the government, or the new national government, would be most liable to infringe upon these precious civil liberties. But as the text points out, this original listing of rights was only understood to affect or limit or apply to the national government. And that was secured in 1833, an important case also written by Justice Marshall, John Marshall, the same author as in McCulloch v. Maryland or Marbury v. Madison, etc., or Gibbons v. Ogden, who held that the Bill of Rights was only applicable to the national government. It did not protect the citizens of state governments against their own governments. For that, citizens of states had to turn to their own constitutions. Now, what was the problem? The problem was, of course, after the Civil War and the 13th Amendment that abolished slavery, is many of the states passed what were known as black codes, which differentiated between the civil rights, which they extended to their white citizens, and which they often limited by, for instance, with curfew regulations or prohibiting a white citizen from being sued by black citizens. In other words, the state governments reacted to the 13th Amendment by creating a second class of citizens, of former slaves and African Americans, who were disadvantaged in terms of the enjoyment of their rights. Hence, in 1868, the 13th Amendment was followed by the 14th Amendment. Now, you already are familiar with the 14th Amendment because I've already discussed this earlier in the course and just in our last several lectures in connection with Dred Scott. Because remember, it overturned Dred Scott insofar as Chief Justice Taney in that case had held that African Americans could not be citizens of the United States because there was no definition of national citizenship in the original Constitution. The 14th Amendment addressed that by defining national citizenship, then went on to address the condition of the second-class status that many states of the former Confederacy had extended. Now, as you'll see, so the next several clauses of the 14th Amendment we'll discuss in a second, which I'll just go ahead and quote the first part, but then with accentuation on these following clauses. They were attempted to make sure that states, when they secured the civil rights of their own citizens, did not do it in such a way that they created second-class citizens. Now, of course, originally the 14th Amendment was intended to address the problem of unequal treatment of African Americans by state governments, but of course the principles are universal and applied, and have been applied and extended to all other classes of citizens too. So here's the 14th Amendment in its entirety in the first part. All persons born or naturalized are citizens of, and subject to the jurisdiction of the United States, are citizens of the United States and of the states wherein they reside. There you have natural citizenship by birth or national citizenship by birth or naturalization, and state citizenship by residency. No state shall deny or abridge the privileges or amenities of the citizens of the United States, nor deny to any person, nor deprive any person of life, liberty, or property without due process of law, nor to deny to any person within their jurisdiction the equal protection of the laws. And you can see how those three clauses were intended to address the deprivation of civil rights by state governments of the rights of African Americans after the Civil War. Now, the problem is then, what was the 14th Amendment intended to do? Was the intention of the 14th Amendment to overturn Barron v. Baltimore in 1833 and to now apply the Bill of Rights to the states? Obviously, the answer to that question is partially because the 14th Amendment borrows some of the language of the Bill of Rights, particularly the Due Process Clause, depriving persons of life, liberty, or property without due process of law, which comes from the 5th Amendment. So clearly, the 14th Amendment was meant to apply some of the protections which the Bill of Rights holds to citizens against the national government or persons against the national government and apply to the states. But, as you're going to see very quickly, the question of just how much of the Bill of Rights applied to the states became a critical doctrine of controversy or controversial doctrine. And let me just suggest that, and the text does a good job of articulating how the court eventually came to find more and more of the Bill of Rights in the 14th Amendment. But as you shall see, it's difficult to say what exactly the final disposition of the court is I think there is a way to characterize the court's final position on this, as you'll see, but it's complicated, and that will also take us, as you'll see, into the material in Chapter 5. So there are actually 4.5 versions of this question of whether the 14th Amendment was intended to apply the Bill of Rights of the states, because this has been the largest revolution in civil liberties and civil rights, has been not in the national government, although many of the aspects of the Bill of Rights have played out vis-a-vis the national government, but it's the application of the Bill of Rights to the states, and also the Equal Protection Clause of the 14th Amendment, which has led to most of the great debates about judicial philosophy that we talked about in our previous lectures. So let me just say that let me deal with the last position first. The non-incorporation position, if you're looking at the notes, actually, this is the last position mentioned, but let me start with that. This position holds, and there have been important justices like Justice Harlan II and Justice Frankfurter on the court who hold that the 14th Amendment has nothing to do with the Bill of Rights, but that the requirements of due process and equal protection, which are in the 14th Amendment, were meant to be decided by the court and used as a standard independently of the Bill of Rights, but case to case. That position lost out, and therefore it's the other incorporation positions that have become dominant on the court. Here are the different varieties. First of all, and only one justice on the court has really held this, and that's the total incorporation position. In this case, the 14th Amendment, the primary purpose of the 14th Amendment, this was Justice Hugo Black, mentioned several times in Chapter 12 and in this chapter. Hugo Black, appointed by Franklin Roosevelt, held that the purpose of the 14th Amendment was to overrule Barron v. Baltimore, and apply the Bill of Rights to the states as they had been applied to the national government. The problem is there's not much historical evidence for that, and no other justice really stood forward and argued that, although some allied justices adopted the next position, which is let me go back. It's total incorporation plus. A couple of justices besides Justice Black, Justice Douglas, for instance, and Justice Murphy and Rutledge in the Roosevelt courts, held that the Bill of Rights did apply all of the Bill of Rights plus any fundamental rights that were not listed in the Bill of Rights. And this, as you're going to see when we talk more about this later here and in Chapter 5, has to do with the Ninth Amendment. The enumeration of certain enumeration of certain rights in this Constitution shall not be understood to disparage or deprive individuals of rights not listed. It's the non-enumerated rights. So some justices have argued that the court is obligated to discover, and this, of course, you can tell has more to do with the judicial activist or living constitution theory by Justice Brennan. And the particular right that is and you'll see this has played out in the court's jurisprudence, has been the right of privacy. The actual official doctrine of the court is called selective incorporation. Since most of the justices on the court, going all the way back to 1921, when it began to apply certain provisions to the states, no majority of justices has ever held that the entirety of the Bill of Rights was meant to apply to the states. But then you're left with an obvious question. If some of the Bill of Rights apply to the states, but not all of them, which ones? And the doctrine that was formulated to answer that question is called the doctrine of selective incorporation. That is to say that 14th Amendment does not make all of the Bill of Rights applicable to the states, but only the fundamental ones. Now, the attentive among you can tell that just kicks the question down the road kicks the can down the road a few paces. Because if you say, well, the Bill of Rights, only the fundamental rights, the 14th Amendment applies some of the Bill of Rights to the states, but not others. Which ones? Only the fundamental ones. Obviously, the next logical question is, well, which are the fundamental ones? How do you know which ones are fundamental? And in 1936, Justice Cardozo, in Palco v. Connecticut, which interestingly enough denied the privilege of double jeopardy to state cases, tried to give a formulation of what a fundamental right was. Those rights, he said, which were central to the scheme of ordered liberty. That's a nice definition and a nice principle. And in reality, what had happened was, by that time, is the court had decided that some rights applied and some didn't. So what Cardoso was trying to do in articulating this selective incorporation approach was to find a way of distinguishing between those rights which are and those which are not fundamental. Now, as the Wilson text points out, as time has gone by, um, uh, uh, almost all of the Bill of Rights has now been incorporated into the 14th Amendment to this doctrine. You'd have to say that, though, the real doctrine that has governed the court is selective incorporation plus. Because, again, you could say that some justices, perhaps the majority of the justices on the court, especially since the 1960s, when the right of privacy as a constitutional right was fully formulated, have held that these fundamental non-enumerated rights are also part of what the 14th Amendment applies to the states. So basically, the answer to this question is that almost all of the Bill of Rights and a few more rights not listed in the Bill of Rights are now incorporated in the 14th Amendment as judicial standards to weigh the police powers of the state, as you'll see in the next chapter. So let's conclude these remarks on civil liberties by going through several of the specific issues and the different areas of jurisprudence that the court has formulated to deal with some of the specifications of the Bill of Rights and different thematic groups. The first half, and A and B in the notes, have to do with speech and expression, and we'll discuss some of the categories and doctrines which the court has formulated in there. So, interestingly enough, only one justice on the court has held that the Bill of Rights, especially in the First Amendment, are absolutes. Here's what the First Amendment says. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, nor passing any laws which abridge the freedom of speech or of the press or the right of the people peaceably to assemble or to petition the government to redress of grievances. 5 rights in the First Amendment: religion, speech, press, assembly, petition. So only one justice, the same justice who held that the 14th Amendment equaled the Bill of Rights, the total incorporation, was Justice Douglas, who also held that the First Amendment rights are absolutes. No other justices on the court, and the entire court, has ever fully held that. And therefore, the court has generally preferred to extend and expand the sphere of liberties of religion and speech, although the religion gets complicated, as you'll see, but has allowed some limitations, particularly in the area of national security. After all, we have laws which classify certain documents. And again, the proper line between national security and the freedom of the speech and press, that's always being debated, and that rule, that special middle point between being free enough to be free and yet limiting freedom for the purposes of military, intelligence, and national security, that's always being articulated. Interestingly enough, libel and obscenity are aspects of British jurisprudence which have survived in our law. And generally, our court has also said that you can have laws which punish people civilly for slander or libel. Now, the British standard is somewhat looser than ours. In the British courts, all you have to do is prove that what you published was false. Ours, because we have the First Amendment as part of our Constitution, is a little stricter. You can still be held guilty of libel if you not only show that it's untrue, but also if it was published with malice. So the standard of what kind of speech is non-libelous is if there's an absence of malice, a phrase that you probably heard before. With respect to obscenity, there the court really got into a thicket. And in the 60s, when it began to break down both national and state regulations on obscene speech, it turned itself into a kind of a mini adult theater where they had to watch all these movies to make sure, because the court tried to formulate a standard that anything that was explicit and had no redeeming social, political, or cultural value was obscene. Well, you can say that in practice, but actually distinguishing. And as the text points out, as a society, we've gone pretty far in expanding that. but still there are limitations. And then with respect to the categories of symbolic speech is kind of bridges the category between speech and action. Under the First Amendment, you can pretty much say and publish anything you want. The problem is, can you do anything you want in the name of expressing yourself in speech or press? For instance, if I believed that clothing was a hindrance to personal expression, I could walk down the street naked, and I could claim that that no civil ordinances or local zoning restrictions or anything like that about indecent exposure affect me because I'm expressing a principle. But as the chapter points out with respect to burning your draft court and that kind of stuff, the court has allowed some latitude in actions that are expressive of opinions, but generally has held the notion that you can't use the expression of an opinion to violate otherwise normal, valid civil legislation. But some jurisdictions have taken this to invalidating laws with prostitution, etc., on the grounds that this is self-expression. With commercial and youthful speech, well, you'll notice on television there are no ads for cigarettes, and that's because the government banned them. And it argues that with respect to certain commercial speech having to do with the nature of a product and everything, you can limit what can be said in order to advocate the purchase of a commodity. And with youthful speech, generally speaking, the court has held that young people have rights to self-expression, but not fully as adults. So the court generally has tried to expand the realm of personal liberty and expression in these kinds of rights, still recognizing some limitations on them. With respect to religion, remember there are two clauses that the government shall not deprive you of the free exercise of religion, yet, and then also shall pass no law respecting an establishment of religion. Again, there's some ambiguity as to why the drafters of the First Amendment, because Madison's original version of this, when he submitted them in the House in 1789 and 90, simply said no national religion shall be established. Clearly, it was making a distinction between the power of the national government. You could say no national religion shall be should be established, was added to Article 1, Section 9, and saying that Congress can't actually set up an official national religion. Why did they change it to Congress shall make no law respecting an establishment of religion? And the best scholarship suggests, interestingly enough, that the framers were trying to deprive the national government of setting up an official religion, but also wanted to prevent the national government from interfering with the established religions of the states, because at that time 6 of the states had official some version of a Christian denomination religion. So clearly, the incorporation doctrine and the expansion of the wall of separation understanding of establishment has now applied to states. So, for instance, almost all the states before 1962 had some kind of official prayer in the public schools, but in 1962, in Engel v. Vitale, the court held that schools could not sponsor official prayer. And so the Establishment Clause is one of those areas where the court's been very muddled and very inconsistent. Generally speaking, it erected a 3-pronged test in the Lemon case in 1973, I believe it was, which said for both a state or the national government not to violate the Establishment Clause, a law had to have a secular purpose, a secular intent or effect, and avoid excessive entanglement. Well, you can hear in the word excessive entanglement, there's a lot of fudge factor. So as a result, we still have in God, we trust in our money, we still have chaplains in the services, and we still have both houses of Congress start their daily sessions with prayer. So the Establishment Clause has been held to be pretty high, but not absolute, both on the state and national level. The last major category I'll discuss in this has to do with crime and due process. There's a good discussion of what has come to be known as the Exclusionary Rule. Now, the Fourth Amendment with search and seizure, the Fifth Amendment with due process and non-self-incrimination and non-double jeopardy, the Sixth Amendment with trial by jury and public trial and speedy trial, puts in place certain procedural standards for a fair trial, generally expressed in the concept of due process. And but then obviously the police may violate these things. It may violate the Fourth Amendment. It may violate certain aspects of the Fifth Amendment. And so, in some ways, the question is, how do you enforce the Constitution's values with respect to properly gained evidence, etc., like that? I have to say that, generally speaking, this is where our jurisdiction is different from the British and other national jurisdictions on this, because British law generally allows courts to apply evidence even if it was obtained illegally, as long as it's valid evidence. That the way that evidence is obtained doesn't affect the validity or relevance to the guilt or innocence of a party. But in our jurisdiction, since the 40s, 50s, and early 60s, we've adopted what's called the Exclusionary Rule, which is, now don't forget, there are other ways to punish police for violating civil rights, such as fining them or even criminal punishments. But since the 50s and 60s, the main standard that the courts have adopted is to exclude evidence gathered illegally as valid evidence within a trial. So that was very controversial, still is to some degree, and it came to its perfection in some ways in the most important Supreme Court case that has affected criminal procedure in the United States, and that's the Miranda v. Arizona case. And most of you know the Miranda rules. You have the right to remain silent. You have the right to an attorney. If you don't have one, will be perverted. Anything you can say be used against you. The 4 Miranda rulings. And to some degree, that has become a fixed part of our law. It was very controversial. It was a 5-4 decision on the court, and it was severely criticized by judges on the court. Generally speaking, though, it's held up over time, and you could say that to some degree, the question is not whether the Miranda rulings will or won't be a permanent part of our constitutional law, but rather what the extent of it. There have been some attempts to peel it back, like good faith exceptions, etc. Now, the other area, which is not really dealt with in Chapter 4, I talked a little bit about this in my last discussion, and that is the death penalty and cruel and unusual punishments, because talk about the vague language of the original Constitution, cruel and unusual is pretty vague in the Eighth Amendment. So, at one point in 1972, the Supreme Court decided that the death penalty had become, because of moral evolution of the American people, inherently cruel and unusual, even though the language of the Constitution explicitly authorizes it. But the court overturned that decision in 1976 and allowed death penalty to be reinstituted. And then right after that, I can't remember the exact date, Utah was the first state to execute an individual with the firing squad, by the way, interestingly enough. Now, the Eighth Amendment and the 14th Amendment Incorporation Doctrine has applied the Eighth Amendment to the states, and generally speaking, the court still allows executions to take place and has applied the standard of not excessive cruelty. And for instance, there are debates about with even lethal injections whether or not there's pain experience. So at least at this point, that's where that issue stands in our constitutional law. States and the national government may execute people, but the method of execution has to not violate the cruel and unusual punishments clause. The last major area, which I won't discuss fully in this discussion, but we'll wait until the next class, is the question of the right of privacy, which is not listed in the Constitution. It's not one of the enumerated rights in the Bill of Rights, but is part of this expansive jurisdiction and part of the debate between the originalists and the living constitutionalists, between the restraintists and the activists, is the preservation and extension of this right. It was first found in a Connecticut case, Griswold v. Connecticut in 1965. Connecticut had prohibited the sale and distribution of birth control to married people, to anyone but including married people, and the court overturned that on the grounds that this invaded married people's right to privacy. And then not long after that, it was extended to individuals. And then, of course, one of the most infamous cases after Dred Scott is, of course, the application of this judge-generated or judge-discovered right of privacy to the question of abortion in Roe v. Wade in 1973. So the controversy about this expanded right and this whether or not its constitutional ground and existence and its scope is still controversial. And my guess is we will be discussing the nature, the constitutional grounding, the scope of this right for many years to come.